Welcome to this first lecture covering the gender discrimination topic. Let's begin. There's an interesting story about the way that gender was added to Title VII. I don't know how true it is, but certainly it's true that there is no discussion about whether sex should be added to the categories of protection under Title VII. There is no discussion. Some people think that the congressman who recommended that it be added did it as a joke. The idea being, well, let's see how ridiculous this law can get. Surely once I give this extreme example of where we might be going as a culture, people will wise up and realize we don't need this law at all, because everyone agrees that that would be a silly category to add to the law. That's one theory that people have as to why this generally conservative congressman recommended the addition of sex to the categories of Title VII. But it's also true that this congressman had a history of having female staffers in positions that women did not usually occupy. So he seemed unusually supportive of women at a time when that wasn't as common or as popular as it would be today. So quite possibly there was a mixed motive. He may have been sincere in some sense, but there may also have been a desire to derail Title VII generally. So who knows what was going on in his mind. But it's kind of an interesting story from that perspective. I want to give you a little note about terminology. In the last few years, there's been a lot of discussion about what does gender mean? What does sex mean? For the purposes of this lecture and the next lecture, when I use the term gender and sex, I'm using them interchangeably. And I'm using them to refer to individuals who are anatomically male or anatomically female. In other words, I'm not talking about people who fit into the transgender category. We have another module on that. But we're really focusing on people who were born with genitalia consistent with a particular gender, and they've lived their lives with that being their identity. So I wanted to make sure that everybody was on board with the way that I'm using this term, and then we get to another module, we'll talk about differing interpretations of those words. Okay, so the first topic is, does gender discrimination still exist? I think we all know that it does, but here are some statistics or some information that may be relevant to this topic. For one thing, both men and women can experience gender discrimination, although certainly the vast majority of gender discrimination claims filed are filed by women. Women are more likely to experience employment actions when they are taking on caregiving responsibilities in the family. That could be taking care of minor children or perhaps of elderly family members. Women represent about 2/3 of all poor adults, and women make a little bit less than 80% of what men do across all levels of educational attainment. And there is some wage disparity represented in every profession. At the very top levels within an organization, or within most organizations, it's dominated by white males. Now, going back to the topic up here, let me just pause and talk about this for a second. This is a very complex issue, and I am not at all claiming here that there are not different ways of looking at this data, and certainly I'm not alleging that women as a category are paid 21% less than men when they have similar education, similar work experience, and they work the same number of hours. So please don't think that I am making that statement. But even when you subtract out all of those differences, there still remains a wage disparity between men and women. not 21%, but it is statistically significant. And so what I like in this presentation is not to focus on whether it's 79% or 92% or whatever the number might be, because I've heard differing numbers and many of them have reasonable arguments associated with them. But the point is, it's not 100%. And that's what I hope the takeaway from this will be. So let's talk about gender discrimination and how it affects the employment process. So let's consider it at the very beginning. Employers may not advertise for openings focusing on a particular gender. We can't say that we want to hire a fireman. Obviously, the term fireman implies that women who are firefighters are not welcome to apply. If we say sales girl, we're excluding men who work in sales. If we say he, we're excluding she. If we say she, we're excluding he. Even terms like maid have implicit in them the meaning of gender. So it'd be better to refer to the person as a janitor or a housekeeper or something along those lines. You also want to make sure that your application is free from questions that assume a particular gender or use a particular gender. And you want to make sure that your interview questions are gender neutral. You don't want to have questions that you ask only people of one gender and not the other. That's one of the reasons why it's a good idea to have prepared questions. Whenever you prepare questions, you also have to be prepared for the circumstance that you get an unexpected answer, or a person has a particular aspect to their application or resume that raises a question. So you shouldn't be locked into those questions that you prepared ahead of time. But it's a good practice to have generally a list of questions that you're going to work from. And when and if you add to those questions, you ought to have a justification that's unique to that person, but isn't unique to that person's gender or race or age or something along those lines. So let's consider this situation. Bob is interviewing for an attorney opening. One of his candidates is married. He asks her if she's married and if she intends to have children. Those questions are not absolutely unlawful, but they're really unwise. And the way Bob did it actually is unlawful, because his next candidate is Larry, who is male. And Bob doesn't ask Larry any of those questions. Now, obviously, Mary was only in her interview, so she doesn't know what Bob asked or did not ask Larry. But if she's asked those two questions, you can believe in her mind she's wondering, am I being asked these questions because I am a woman or not? Now, let's say that Bob had asked those questions of Larry as well as Mary. I would still say, why is Bob doing this? What business is Bob whether Larry and or Mary are married and whether either one of them intends to have children? So those are questions are best not approached at all in an interview situation. When you are, it used to be before Title VII, in fact, that many states had laws that we see as very paternalistic. I prefer to think that they were motivated by decent motivations, even though they were maybe a little paternalistic. And that is that many statutes prohibited or restricted the ability of employers to employ women in shift work, for example. Another thing that we saw often in some states was that women's bathroom, if an employer had women employees, women's bathrooms needed to have a lounge area where women could privately relax to some extent outside the workplace. I used to have a client who had an older facility, and I happened to go to that facility and use the bathrooms. As a woman, I went to the ladies' room, and I went in there, and it was like there was a sitting room. There was, some plastic flowers in a vase. There were a couple of sofas, and I was like, this is unusual. And so I took care of my business and left. I did not use the sofas. I didn't see anyone else using sofas. So I went back to speak to the client. I said, I had an interesting experience. The bathroom had like a living room associated with it. And of course, the HR manager with whom I was working said, yes, that was a state law many, many years ago, again, before Title VII. And of course, in some sense, Title VII repealed those laws, although they were usually not taken off the books. And this particular employer had to have an oversized ladies' room as a result. The men's room obviously didn't have the couches and the flowers. It was just a functional bathroom, and so it was significantly smaller in comparison. And they said, it never made sense to redecorate or take down the walls and remove some of that space. And so since we had the dead space, we put some soaps in there. But it was kind of a funny moment from that perspective. Now, I'm sure the legislators who passed those laws thought that they were extending a kindness to women workers, giving them a place where they could privately take a break, where they wouldn't maybe be exposed to men who might be making salacious or inappropriate remarks. And they were also thinking they were protecting women by restricting their hours of work, the idea being it might be dangerous for a woman to be coming and going in the middle of the night. Plus, back before cars were as common, it might have been dangerous for women to be riding buses or walking to work. And so it's very possible that those laws were designed to protect women and may have even had added value to the lives of many women. But certainly in modern times, those laws are no longer in effect, even if they haven't been repealed. And the fact is that there is no need to have a lounge room in a bathroom, and women are just as capable and entitled to work the late shift as men are. And in fact, many women prefer to work the late shift because many times there is a wage differential for people who work less popular shifts. So there can be lots of reasons why women might want to work different shifts or be in different job positions. And women shouldn't be excluded from those jobs unless gender is a BFOQ, a bona fide occupational qualification, which will rarely be the case. So let's consider the situation. Bob's bar needs some bouncers. Obviously, a bouncer needs to be rather impressive looking, be a little intimidating, and be able to break up a fight or persuade people to disperse when there seems to be some tension. Bob only interviews male bouncers. He hires women for lots of other jobs, so he's not thinking that he's violating the law, but he is, because it's entirely possible that a woman could be an effective bouncer. She might use the same intimidation techniques that a man uses, or perhaps she might use a different set of techniques that would be equally effective. And so Bob would be discriminating by excluding women because being a man is not a BFOQ for an effective bouncer. Women shouldn't be subject to different discipline because they are women, and they shouldn't be different training should not be available to men versus women. In this case, Bob is trying maybe to do the right thing. Maybe he's aware of the fact that historically women haven't been as welcome in the IT community as men have been, and so he wants to give women a little bit of a boost by reserving certain training exclusively for them. But that, of course, would be unlawful. To exclude men from training is an act of gender discrimination against men. And so that would be unlawful to provide any training just for one category of individuals. Sometimes seniority programs are problematic as well. These also can negatively impact minorities. And that is because the more recently hired folks, which sometimes are women and minorities, are usually the first individuals to experience a layoff if the business needs to do a layoff. And that's because of the LIFO effect. You may have heard of this in the context of accounting. Last in, first out. So if you have two workers in the same job, one was hired 5 years ago and one was hired 2 years ago, most employers are going to lay off the 2 years ago person before the 5-year person, especially if they're performing at the same level. So if the woman is the more recent hire, then obviously she'd be the one that would go. Now, of course, it could be that the woman is a longer service person and then it would be the man who's going. But as we become hopefully more equal in terms of employment, then that means more women are more recently hired. So And that can be a challenge, both again for women and minority candidates, minority employees. Can't offer different wages or benefits to individuals doing the same work. So in this case, male employees are entitled to ensure their families, their spouses, presumably probably wives in most cases, although that is, it could be a husband, in the health insurance program. But female employees only get to cover themselves, not their spouses. Under those circumstances, female employees would have a claim under Title VII. I'll tell you how this sometimes plays out with employers. It is not, as you can imagine, health insurance is a major expense for employers. And so employers recognize that while it can be an important benefit that attracts and retains valuable employees, it is an expense that needs to be managed. And so some approach that employers do is say, well, we will provide health insurance for the employee, but we won't, and usually for the employee's children, but not for the employee's spouse. That's perfectly lawful as long as the employer applies that same standard to women employees and male employees. But another twist on it that sometimes happens is that the employer will say, we will provide health insurance, assuming the employee signs up for it and agrees to pay his or her premium. We will provide health insurance for our employee and the children, but we'll only provide health insurance for the spouse if our employee is the major breadwinner for the family, meaning that our employee earns more than half of the income for the family. But if the spouse earns more than our employee, then we will not cover the spouse. And the idea here is, well, the spouse is earning more than the employee of the employer, probably that spouse can get health insurance through his or her place of employment. And so that's a way to manage the cost of the health insurance. Now, as a practical matter, oftentimes, certainly not all the time, but usually the woman in a traditional man-wife marriage earns less than the man. Not always, but statistically more likely than not. And so that means that an employer that has this policy, more of its male employees will be covering or having the opportunity to cover the spouse than the female employees. But that has been held to be lawful. So that's an interesting twist that hasn't been held to be a violation of Title VII. Different terms or conditions of employment are, of course, unlawful. You can't require one gender to work different hours or have different job responsibilities. So in this particular example, this company hires both men and women, but the company mostly promotes only men to senior sales executive positions because the job involves a lot of traveling. And this company thinks, well, women aren't going to want to travel. They have young children. They have home responsibilities. And certainly some women would turn down the position, as would some men. But there would be other women who would relish the opportunity to travel. And it's really not the role of the employer to decide whether this would be in the best interest or not of women. The gender of the candidate isn't relevant. It's the skills that that person possesses and their level of interest in this particular position. And of course, in termination decisions, gender shouldn't be a factor. So let's consider this situation. Harry and Mary are two workers who work for this company. They're both busy over the weekend for different reasons, not doing anything together. And they fail to show up for work on Monday. When they return, Harry's given a verbal warning. Mary is dismissed. If there's no additional facts in this scenario, Mary has a possible claim for gender discrimination. You can't be more strict for women than men. You can't be more strict for men than women. Now, of course, there could be a lot more going on in the story. For example, maybe Harry's reasons for not showing up on Monday were more reasonable than Mary's, or maybe Mary had done this in the past and had already received her verbal warning. But assuming there aren't additional facts like that, then this does look like a case of gender discrimination. We've talked about the prima facie case framework lots of times, so I'm not going to do it again here. It's the same framework we talked about with race discrimination. and the same framework we talked about when we talked about national origin discrimination. Obviously, here the protected category is being of a particular gender. Obviously, we're all of one or another gender, and so therefore we're all protected, men and women. And then, of course, the employer would have the opportunity to rebut the prima facie case, and then it would go back, kind of like the ping pong thing. It'll go back to the employee to rebut the reason offered by the employer. Let's consider this case. This is not a case you need to know, but I think it's an interesting one, and I think the result may be surprising to you. Now, this is a Seventh Circuit case. I'm not sure that every single circuit would come down in exactly this way, but this isn't a tremendously unusual result. So let's look at this. In order to sue successfully for sexual discrimination, must a plaintiff show evidence of discrimination beyond the fact that someone of the opposite sex was awarded the job that the plaintiff wanted to retain. Okay, so again, we're talking kind of about the prima facie case and possibly the rebuttal case that needs to be presented. So in this situation, we're going to say that the plaintiff is a male. As we'll see in this case, it is a male. And of course, the opposite person, the opposite gender was a female. So he's able to prove that he's male. He had the job, so he was obviously qualified for it. He received an adverse action. We'll see that he was dismissed and he was replaced by a female. So it looks like he satisfied the prima facie case, but he wasn't ultimately successful because we'll see as the facts progress. When the employer rebuts the case in the way this particular employer rebuts, the employer was successful. You may not agree, but that's what the law says. So in this case, this is actually a dental case. So Jay Preston, who's the plaintiff, is a dentist, and he worked for a company. He managed a particular dental office for the company. Unfortunately, that particular clinic had not been profitable for many, many years. In fact, it had lost money. Well, Preston was trying to come up with ideas, marketing tools, more efficiencies or whatever, so that the business could become more successful. He did not persuade his employer, though, that his plan would work, so his employment ended at that point. And again, you can see a lot of qualifications. Obviously, he was a dentist, so he had the dental credentials, but he also had an MBA. Well, Preston was replaced by a woman, Hamilton. She's much younger. Okay, fine. But other than the fact that she's a dentist, I guess she's a dentist, she didn't seem to have on paper the credentials that Preston had. But here's the wrinkle. The CEO of this company, not sure how he pronounced his name, Trojak perhaps, Trojak and Hamilton seem to be having a romantic liaison. And so the idea is maybe the reason why Preston was fired was so that the CEO could put his girlfriend in position, give her a source of income. The holding of the case is that the replacement of a male employee by a female employee because of romantic motivations isn't sex discrimination, it's favoritism. And favoritism falls under that at-will employee idea. You can be a jerk, you can have mean intentions, you can make stupid business decisions. And those are protected categories. Remember, we talked initially in an earlier presentation about all the reasons you can fire somebody. And there's really just a few unlawful ones. As long as you don't use one of those unlawful ones, you can pick a really stupid reason, a really mean reason, a really immoral reason, and those aren't going to create a cause of action for the quote-unquote wronged employee. This is an example of how at-will employment kind of is still alive and well, I guess you could say. You don't need to know the name of this case. I'm providing it just kind of for exemplary purposes. We're not going to have the same statute of limitations that we had for race and national origin discrimination for sex discrimination. After all, they're all from Title VII. So we have the 300 days in Texas because we have a 706 FEP agency. If there is no FEP agency, we're going to have 180 days. But there is one important exception to this policy. And we've talked about the Lilly Ledbetter Fair Pay Act a couple of times. We'll talk about it some more later on, but let's just pause and do a little bit deeper dive into this statute at this point. So Miss Ledbetter worked for Bridgestone Firestone, I believe was her employer. She was hired, I believe, in the early 1970s. It was after Title VII was in effect, but honestly, there were still lots of opportunities to increase the level of compliance. About the time she was hired in this particular plant, there were several men who were hired as well. Her in-hire rate was significantly lower than these male employees, even though there didn't seem to be an obvious reason why they were hired. They didn't necessarily have more education or more relevant job experience. Now all of these workers started working in the facility doing roughly the same type of work. And years went by, they continued to work and they continued to get increases from time to time. And sometimes the increases were, 25 cents more an hour, but sometimes they were on a percentage basis. So they might get a 3% increase. So you can see if I earn $10 an hour and I get a 3% increase, then now I'm going to be earning $10.30 an hour. But if I were only earning $8 an hour and I got a 3% increase, I'm now only going to see 24 more cents an hour. So the wage difference used to be $2 between me and the people earning $10 an hour, but now it's $2.06 an hour. So you can see how the gap between the lower wage earners and the higher wage earners over time can actually increase. Anyway, so throughout this time, it was not permitted for employees to discuss amongst themselves their wage rates. And as you can imagine, even if it had been legally okay, that's not something people usually like to talk about very much. So Miss Ledbetter really had no idea. She kind of assumed everyone was earning the same amount of money. Well, near the time of her retirement, she found out from some of her coworkers that they were earning significantly more. And so when she retired, she filed a claim against her former employer saying, hey, for the last, I don't know if it was 20 years, 30 years, I was underpaid. I don't know if it was 50 cents an hour or $1 an hour. But think about it, that's 2,000 hours a year, plus maybe 20 years. That's a nice amount of money when you think about it from that perspective. And Ms. Ledbetter felt that she was entitled to recoup that money. Well, of course, Bridgestone Firestone disagreed with that analysis, and it went up eventually to the U.S. Supreme Court. And the U.S. Supreme Court said, well, Ms. Ledbetter may well have had a claim back in when she was hired during the first 300 days after her employment began during her statutory period, assuming this particular state had a 706 agency. But she didn't file at that time, and so therefore any claims that she would have expired, and she can no longer advance her lawsuit. Well, this decision was a lightning bolt to the Congress. They were, as a group, very displeased with this decision. And as sometimes happens when the Congress disagrees with a decision of statutory interpretation on the part of the U.S. Supreme Court, the Congress decided to amend the statute. As we know, when a court interprets a statute and the statute changes, then the relevance of that initial decision becomes nothing. It's no longer good law. The language that it was interpreting is no longer the language of the statute. And so going forward, the new interpretation or the new language of the statute would be what will control. And in fact, in this case, since it was very obvious that the Congress was intentionally rejecting the interpretation of the U.S. Supreme Court, it was even less likely that there would be any continuing relevance or continuing precedential value to the U.S. Supreme Court decision. And so this is how we got the Lilly Ledbetter Fair Pay Act.
It's named after her, but unfortunately for her, she never got any money out of it because, of course, the law can't be retroactive. And so the law doesn't help Ms. Ledbetter, but it helps people who in the future choose to sue under facts similar to Ms. Ledbetter's. Now, this is a controversial statute. One can see the arguments in favor of it. After all, Ms. Ledbetter really never had a chance. No one's going to go around snooping and trying to figure out what your coworkers earn, especially when you're just beginning your employment and you know it's against company policy to ask those questions. You might well offend your coworkers and or get fired. And so one can't blame Ms. Ledbetter for not knowing about the pay differential. And if you don't know about something, you can't sue about something. So there's a lot of intuitive arguments in favor of the Lilly Ledbetter Fair Pay Act. But there's also arguments against it. And let me make this argument, not so much because it's relevant to what the law ought to be, because after all, the law is the law. This is the law. But I want to offer this critique to you, not so much because it's going to not change the law, but it's going to show you some of the challenges your clients will face in complying with this law. So let's imagine that Lilly Ledbetter, let's say the Lilly Ledbetter Act had passed before Lilly Ledbetter filed her lawsuit. Obviously, it would have been called the Lilly Ledbetter Act. So she is now going to file her lawsuit, and we'll say that we'll say she was hired. We'll keep the timeline the same. We'll kind of go back in time, say to 1990. We'll say that the Lilly Ledbetter Act is being passed in 1990. I can't remember the year of it. And so Miss Ledbetter worked for, we'll say about 20 years for her employer. And now she's saying, well, that decision 20 years ago started me on this track of earning less money. So that was the unlawful act. That unlawful act in some sense is continuing to my final paycheck because I'm still earning less money than my coworkers, and yet my performance has been as good as their performance has been. So there's no merit differential between my work and their work. And so that initial decision is still discriminating against me, and that initial decision was unwarranted. Well, let's think about it from the employer's standpoint. 20 years has passed. Think about that HR department. Is the same person who hired Ms. Ledbetter likely to still be around? That person may not even be alive anymore. Easily could be retired or could have moved on to another position. Even if by chance that person is still around, how likely is it that that person is going to remember Ms. Ledbetter as an interviewee, or the males who were interviewed around that same time? How will that person be able to even say the reason why Ms. Ledbetter was offered one wage rate and the other individuals were offered another wage rate? They're just not going to remember. They probably, if they've been in that position for 20 years, they've probably hired thousands, maybe tens of thousands of people. So they won't have any recollection. It could be that there is a completely legitimate reason why Ms. Ledbetter was given a lower wage rate than the men, and it may have had nothing to do with gender. We just won't ever know because there won't be a paper trail, there won't be documentation, and the people who made the decision aren't around to know about it. So the takeaway is you have to document decisions. And you can't just say, well, you know what, that happened a long time ago. Who cares why we did it that way? Well, again, even though it's happened something well over 300 days ago, that decision can still be reanimated as we see in the Lilly Ledbetter case. Now, one thing I do want to say about the Lilly Ledbetter case, just to be clear on it, is that even under this act, someone in Ms. Ledbetter's situation would not be able to recoup all of the money that she lost. So if you think about it like this, let me just draw a picture of it. So here is the day of hire. Ms. Ledbetter was earning this much, and her pay went up over the years. And men were hired at a higher rate, and their pay went up over the years as well. And this is the day that Ms. Ledbetter filed her lawsuit. Now, in the perfect world, what she'd like to do is capture all of this money differential from day one to the last day. But that is not what the Lilly Ledbetter Fair Pay Act permits. It only permits a 300-day look back. So 300 days. Again, we're assuming there's a state FEP. So we're going to go here. And so she would be able to recoup this money. This part, the part before the 300 days, she would still be timed barred from recovery. Every time she gets a new check, so let's assume she's paid, we'll say once a week. So each week is a new discriminatory event if it's based upon this initial pay rate. That is pretty common in most places of employment, that your initial pay rate does shape where your increase goes into effect. Not in every single case, but I would say in most it does. And so that's how the Lilly Ledbetter Pay Act works. It is the law of the land, but it creates opportunities for requirements that employers document, especially that initial pay rate and why the particular pay rate was selected. I'm going to end this lecture at this point. We'll talk about disparate impact and gender plus discrimination in a later presentation. I thank you for your attention, and I hope that you have a wonderful day. As always, if you have questions, please don't hesitate to pop in to my office hours. Take care.